What are the immigration options for my foreign-born fiance if they happen to be in the United States? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. Frequently we get contacted by people who are in love, and we love helping people that are in love. It's a great thing. We really enjoy working on spouse cases and fiance cases, but these cases can be a little bit hairy. They're a little bit complicated, and it's not so much the immigration aspect of it, it's the fact that young people or people who are getting married quickly sometimes have some interesting factual scenarios or different issues that come up in the fiance or spouse context. And a lot of times the real world philosophy doesn't coincide with the philosophy of the Immigration Service. What do I mean by that? Well, what I mean is that the Immigration Service assumes that anyone in the United States is coming here to get married. So that can make things complicated when we're trying to schedule out what to happen. So let's say that we have a hypothetical couple, Mary and John, and let's say Mary is from France and John is from Chicago, Illinois. Well, if we get contacted by John and Mary, there are certainly certain different situations that can arise factually, like where Mary is. Is Mary in France? Is Mary in the United States? And this video today is going to focus on what happens if the couple is engaged and Mary is visiting John in Chicago and the couple is thinking about getting married. So the first option would be for Mary to stay for her visit and to go back home into consular process. Now, we could file the paperwork while Mary is still in the United States, but once she leaves, it's going to be about a year before Mary's able to come back. She's not going to be able to come back on that visit visa. The reason for this is that either she's going to get turned away at the border on her next visit because CBP, Customs and Border Patrol, think that she's coming to stay as the spouse of a U.S. citizen, or even worse, she is allowed into the United States, but then later on she's accused of some kind of fraud for re-entering the United States after having been married to a U.S. citizen. So that option is usually one that we discourage our clients from taking. The other option would be for Mary to come to the United States on that visit, to hang out, and then to go back home and do a fiance visa. Now, we've done this many times, and this is usually the safest way to go. That's the least stressful. It's an approvable case. You know, all we have to demonstrate is that Mary and John have the intention to get married upon her next visit to the United States, and we have to demonstrate that the couple has been in each other's physical presence in the last 2 years. So other than the forms, from an evidence standpoint, this is a relatively straightforward case, and a lot of our clients decide to go this route. So we'll have consults where Mary and John come to see us. Mary's coming to the end of a visit visa, or else she's entered the United States on the visa waiver program, sometimes known as ESTA, and she decides to go back home, and we do the case with USCIS, followed by some brief consular processing, and she's back in the United States in about 7 or 8 months. The last option would be for Mary and John to get married, and for Mary to stay in the United States while her case is pending. So in that scenario, you'd want to make sure that Mary didn't get married within those first 60 days of arrival. If Mary and John get married in the first days after she arrives, then there's a presumption that she had immigrant intent when she came to the United States, and that she tricked the Immigration Service or Customs in entering the United States on a non-immigrant visa when her real intention was to come here and get married. So you need to make sure that the couple doesn't get married in those first 60 days. But after she gets married, she's allowed to file with her spouse for adjustment of status, and you do that by filing an I-130 application for a petition for an alien relative, and that allows her to stay in the United States. Now, during that time period, while that case is pending, it's a little bit hairy. We often call the person in Mary's shoes bubble boy or bubble girl, because they're really in a bubble. For those first 4 months after you file, they're in the United States, but they can't work. And they can't leave the United States because they're waiting for a work authorization and a travel card. And if they leave during those first 4 months after we file, then Mary is not going to be able to come back. And a lot of the filing fees for the adjustment of status, all that will be lost. And all you really have left at that point is the I-130. And then it's extra complicated because Mary has now gone from somebody in the United States to somebody back home that we're going to have to consular process, and to get the petition on the right track again is pretty tricky. So as you can see, there are sort of 3 options for Mary and John. A lot of times the other issues relate to when the couple wants to have a wedding, or they need to travel, or there's some job considerations. These are the kind of things that make fiance cases a little bit more complicated. And like I said, not so much on the immigration side. We can handle that, but a lot of times it involves us mapping out the different scenarios and the couple picking from a life standpoint how they want to proceed. So if you have any questions about this, feel free to give us a call at 314-961-8200. You can visit our website at www.hackinglawpractice.com, or you can shoot us an email at info@hackinglawpractice.com. If you like this video, be sure to subscribe to our YouTube and Facebook channels. Be sure to share it with your friends, and we hope to see you on the next video. Thanks a lot.